conclusion.
Welcome. It's a pleasure to welcome all of you and our excellent panel of speakers to this event, The Natural Born Citizen Clause, a study in constitutional meaning. Between the time that I began thinking about and arranging the panel for today, one event that has some conceptual significance for what we're going to be talking about obviously has occurred. As you all know, Justice Antonin Scalia passed away on Saturday, February 13th, ending a remarkable 30-year career on the Supreme Court since his appointment by President Ronald Reagan in 1986. Media commentators and pundits alternatively commended or criticized what they regarded as his innovative constitutional methodology. A major part of that methodology focuses on the public meaning of constitutional text at the time of ratification. Just to be clear, for particular constitutional amendments, most notably the Reconstruction Amendments, this means the public meaning when those were ratified, as opposed to the public meaning of the same terms at the time of original constitutional ratification. That relationship can be sometimes quite complex, for example, as applied to the meaning of the 14th Amendment Due Process Clause or Privileges or Immunities Clause. Although it's mistaken to imagine that Justice Scalia invented this particular interpretive methodology, it's equally mistaken to deny him the credit for having popularized it and perhaps even for having given it resonance beyond any particular ideological cast. If you read, for example, District of Columbia versus Heller, you will observe Justice Scalia for the majority and Justice Stevens especially, but also Justice Breyer writing in dissent, debating the public meaning of the language of the Second Amendment, including then-present understandings of key terms and of the relationship between the prefatory and operative clauses. If you read Seminole Tribe versus Florida, you'll observe Justice Souter rejecting then-Associate Justice Rehnquist's majority opinion, which was joined by Scalia, and which dismissed the 11th Amendment text as a straw man in determining the scope of state sovereign immunity. Justice Souter instead maintained that the amendment's plain wording and plain meaning are instead the man of steel. I could give other examples, but the point is that the importance of plain text and original public meaning transcends ideological bounds. Today we address the meaning of the Natural Born Citizen Clause. Notice that the program's subtitle is a study in constitutional meaning, rather than a study in constitutional interpretation. I chose this emphasis not because of an absence of important methodological questions that inform interpretive technique. Rather, I did so because at a certain level, the most interesting foundational question about Republican presidential candidate Ted Cruz's qualification is this: is a person born in Canada to a United States citizen mother and who, by virtue of our present statutory regime governing naturalization, became a citizen retroactively to the moment of his birth, also a natural-born citizen based on what the term was understood to mean at the time of ratification? The clause states the following: no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. And that's, of course, Article 2 of the Constitution, Section 1, Clause 5. Under Article 1, Section 8, Congress has the power, quote, to establish a uniform rule of naturalization, close quote. Finally, under Section 1 of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, close quote. As Professor Graber can certainly explain better than most, that sentence, among other things, overturned the infamous Dred Scott case. There are several important interpretive questions. I will offer just a few. First, does the use of naturalization in Article 1, Section 8 carry the same meaning as the word natural used in the Natural Born Citizen Clause of Article 2, Section 5? Second, or is this a textual instantiation analogous to Chief Justice John Marshall's distinction between the use of the word necessary, as used in Article 1, Section 8's necessary and proper clause on the one hand, as compared with its use in Article 1, Section 10 on the other, which states, no state shall, without the consent of Congress, lay any imposts or duties on imports or exports except what may be absolutely necessary for executing its inspection laws. And as those of you who have taken constitutional law know, that distinction between necessary used in the necessary and proper clause versus absolutely preceding necessary in the other clause plays a significant role in the landmark decision McCulloch versus Maryland. The third question, does Congress by statute have the power to affect, or more specifically to broaden the meaning of the natural born citizen clause by retroactively conferring by statute the right of naturalization to the moment of birth for individuals like Mr. Cruz, who was born to a U.S. citizen mother abroad? Despite these interesting interpretive questions, I think the most interesting question is this: what did the framers actually mean by natural born citizen? Finally, I'd be remiss not to add the following. Even if we sort out that question of contemporaneous public meaning, it's not at all clear that this will ultimately matter. At bottom, much of constitutional interpretation rests on who or what, meaning which institution, has the power to decide. Assuming Ted Cruz wins the Republican primary, and further assuming that he goes on to win the general election, will the question as to his constitutional eligibility to serve as President of the United States ultimately be resolved through the voting process? Would the federal judiciary entertain a case raising this issue, or would it instead deem it a political question? And even if the court took the lead of Powell versus McCormick, a 1969 case in which the court held that the question of eligibility to serve in the House of Representatives is not a political question, it's not at all clear who might have standing to raise this question of presidential eligibility to serve in a proper case or controversy. I should add that between writing these comments and the beginning of this panel, I just learned an interesting datum. And that is that Donald Trump personally called Professor McManamon this past Wednesday, inquiring whether she might wish to assist in such a suit. She declined. Today we have a terrific expert panel to address the question of constitutional meaning and more. Mary Brigid McManamon is professor of law at the Delaware Law School. She has a BA in history from Yale. She earned her JD at Cornell, where she served as managing editor of the Cornell International Law Journal. She was a litigator at 2 elite firms in Ohio, where she practiced from 1980 to 1984 before she began her teaching career at Case Western Reserve Law School. She joined the Widener Law faculty in 1985, and she has been on that faculty since, where she's now a professor of law. She is also an acclaimed expert in both civil procedure and constitutional law. She's widely published, having written leading texts and prominent law review articles. As her now famous op-ed in the Washington Post, based on this Catholic University Law Review article, makes plain, and there are some reprints available for those who might be interested, she is also someone willing to engage in public discourse, sometimes even creating a bit of a stir when doing so. Welcome, Professor McManamon. Professor Garrett Epps hails from closer by. He is professor of law at the University of Baltimore School of Law, where he teaches constitutional law in courses in fiction and nonfiction for law students. He earned his BA in English at Harvard and his master's in English writing at Hollins. He has a JD with highest honors and an LLM from Duke Law School. He clerked for the Honorable John Butzner of the U.S. Court of Appeals for the Fourth Circuit, and he has worked as a staff writer for, among other places, the Washington Post. He's a prolific writer of fiction and nonfiction and of law and non-law. He, too, has an impressive list of academic publications, and also publications for a broader audience. Welcome, Professor Epps. Our own Mark Graber is the Jacob A. France Professor of Constitutionalism here at Maryland Carey Law. Professor Graber earned his BA from Dartmouth and his JD from Columbia, his MA in philosophy at Yale, and his PhD in political science also at Yale. Professor Graber is among the most prolific scholars in the legal academy, bar none, with leading textbooks, law review articles, peer review articles, popular press articles, and even blog posts on balkanization. Welcome, Professor Graber. It's a pleasure to welcome you all. Our plan is for each panelist to speak for 12 to 15 minutes, following which we'll open this up for a question and answer period. We're being taped in this session, and it's being simulcast in College Park, where we are co-sponsored with the MLaw program. My laptop is open because there's a possibility I might get a question or two thrown my way electronically. We'll see how that goes. And I'm now delighted to turn this over to our first panelist, Professor McManamon, who will be followed by Professor Epps and then Professor Gray. Thank you.
Thank you, Dean Stearns, for that wonderful introduction. I wanted to introduce myself a little bit as to my approach. Since the Washington Post op-ed occurred, there have been all sorts of comments by all sorts of people saying things like, oh, she must be in Donald Trump's pocket, or she's obviously a lefty socialist academic. I'm not either of those things, and I'm not actually an originalist. A lot of people assume that because I have taken a historical approach. What I am is a legal historian. I really enjoy taking a doctrine and tracing it back to the very beginning to see what I can find about the original meaning. How I came about this topic is sort of happenstance. I teach every summer at the University of Delaware's Lifelong Learning Institute, which is a program for senior citizens. And in 2013, I was looking for a topic that might be of interest to them, and I knew that way back in the 50s, there had been some talk about FDR Jr.'s running for the presidency. Unfortunately, he was born in Canada. In the early 60s, there was Barry Goldwater, who was born in the territory of Arizona, not in the state of Arizona. In 1968, of course, Mitt Romney's father, George, was born in Mexico and attempted to run. So there's all these brouhaha that the class members would have heard about. Then, of course, more recently was John McCain from the Panama Canal Zone, and Ted Cruz was already, having just entered the Senate, was already making noises that he might want to run, and of course, he's born in Canada. So I put together a program for the students, and as I was doing it, as I said, I like to go back to the beginning, and I found that the answer was, despite what people tell you, very clear, and it was modern commentary that had just missed the boat in terms of trying to figure out what it was that was meant by the phrase. We have to turn to the common law to find out the meaning. In America, the states adopted English law, whether common law or statute, by what we call reception statutes. So they clearly went on the books saying, we are adopting these particular laws from England. At the federal level, we have no reception statute. The closest we have is that the framers of the Constitution constitutionalized some common law terms. For example, the writ of habeas corpus is a common law idea. The right to jury trial is a common law idea. These are constitutionalized. So too, the natural-born citizen concept. And the Supreme Court has told us that when trying to figure out the meaning of a constitutionalized common law term, we go to the common law of England. In the 18th century, 17th century, 16th century, the centuries before our own framing, the law was quite clear. The English people saw the world in terms of people who are English and everyone else who's alien. And the idea was that you had to be born in England to be English, which meant that somebody who was not of English parentage could be English, but somebody of English parentage born abroad would not be English. There were nuances to this because the idea was allegiance. Their feeling was, if you're born here, you're an infant, you are totally without protection. The sovereign steps in and grants you that protection, and in return, you owe loyalty and allegiance. That's the theory. So there's some nuance. For example, if you go from England as a diplomat, you carry the flag of England with you, and so your children, the children of diplomats born elsewhere, are going to be natural-born English subjects. Likewise, there was another nuance that if the territory, although English, was out of the control of England but was in the control of a hostile military force, you were not natural-born. And that really is unique to England in that, I don't know if you're aware, but during the Middle Ages, at times, the Crown of England controlled more of France than the Crown of France did. But over time, even though England still maintained that it owned half of France, it had to be realistic and realize that, no, it didn't own half of France, and people born there were not considered to be English. But anyway, the vast majority of people born outside of England are aliens, okay, just very few diplomats out there. And so they began calling people who were not English people born beyond the seas or born in foreign parts. And that included children born abroad to English parents, that is, analogs to Senator Cruz today. If you were an alien, there were quite a few disabilities, legal disabilities. One, you couldn't inherit real estate in England. You couldn't bequeath real estate. You couldn't purchase real estate. And if you got somebody who would sell you real estate under the table, you couldn't enforce the contract. So if they took it back, you were stuck. In addition, you couldn't sit in Parliament, you couldn't sit in the Privy Council, and as many of these people were merchants, this last was very important, you paid double the duties on your goods that English subjects did. So there was a real reason that somebody moving to England might want to become a naturalized subject. You were an alien, but you could have those legal disabilities removed. There's a very famous, at least among us legal historians, famous statute from 1350 in which Parliament removed one of the disabilities that aliens encountered, and that was it allowed children born abroad to English parents to inherit real estate. So that usually well, I'll say always, the dad would go abroad as a merchant, earn lots of money, come back and not be able to pass his money on to his children. And so Parliament said, oh, that's okay. But the other disabilities remained. And the way you would become naturalized was through a private bill in Parliament. This was really expensive. It's not going to sound that expensive when I tell you it cost 50 to 60 pounds. Okay, so what's the big deal? But in the era that we're talking about, it was a huge deal. For a skilled artisan to live, he had to earn 40 pounds. So let's just take it in modern times. Let's say somebody who's a modest, middle-class person, not poor, not rich, earning maybe about $80,000. Right, so if we're taking that as our model for the 40-pound earner in early England, the right to become naturalized would cost you $100,000 to $120,000. Right? So you didn't become naturalized unless you really wanted it and needed it. It wasn't just sort of a frill and extra. And hundreds of children born abroad to English parents became naturalized. Another wrinkle, besides the huge price tag that you had to pay to Parliament, was you had to make 2 oaths, one of loyalty to the king, and one in which you said that you do not accept the Pope as the head of the church. In addition, you had to take the Protestant communion. This meant that Catholics and Jews were excluded. All right. Coming forward, there is a series of statutes in the 18th century that changed this for England, but they were totally revolutionary. Up until this moment, where you were born was where you owed your allegiance, where you owed your loyalty. But in the 18th century, Parliament said, yes, that's still true, but in addition, children born abroad to English parents are also going to be natural born. And why I say this is revolutionary is it never occurred to the medieval English population that you could be born in the allegiance of one king and also in the allegiance of another king. That wouldn't make sense. So this is a radical, drastic departure from the usual way of being. Now, the one thing I need to tell you that's important, and it's very important to the framers of our Constitution, is that in England, they have an unwritten Constitution. And at the 18th century, at the time I'm talking about, Parliament was supreme. The English Constitution meant what Parliament said it meant. And if you look at our Declaration of Independence, we always think about, oh, we were revolting against King George. There are also many provisions in there talking about how we were upset about what Parliament was doing. And so the drafters of our Constitution very carefully made this a written Constitution. Right? McCulloch talks about it. Marbury versus Madison talks about it. The Constitution binds Congress. In England, Parliament determines the Constitution. Here, the Constitution limits the Congress. Very, very, very important difference. Because the question that we're being asked is, what happened here? What version did we apply? There are lots of modern commentators who maintain that we accepted the parliamentary 18th century definition as opposed to the common law definition. What we know about the clause is very limited. I'm going to give you 100% of what we know. The first draft of the clause talking about who could be a president only talked about a citizen of the United States and somebody who'd lived here for 21 years and also 35. You still had to be 35. John Jay wrote a note, which we have, to George Washington saying, permit me to hint that, and then I'm going to paraphrase now, but he does begin, permit me to hint that we should really want our commander-in-chief to be a natural-born citizen. We also have the note that George Washington wrote acknowledging Jay's note saying, thank you for your hints. And 2 days later, the constitutional text is changed to include the natural-born citizen concept. I can't tell you cause and effect. That is 100% of what we know. You can draw your own inferences from it. So, but the question then is, what did we mean by common law, the doctrine of natural-born citizen? Early writers, early commentators, including James Madison, said that place is where we have our allegiance. There are also very important treatise writers. One is a guy named William Rawle, who was at the Pennsylvania Constitutional Assembly. Another is Chancellor James Kent, who is a very influential treatise writer in the early American period. Both of them declare unequivocally that it's the common law meaning. That is, the notion that you had to be born within the territory of the sovereign. A lot of people point to what Congress did, and Dean Stearns mentioned what does naturalization mean in Article 1. According to Madison, the naturalization power is only the traditional power to take away the legal disabilities of aliens. And he specifically said that Congress was not given the power to act on natural-born citizens. Congress only had the power, quote, to admit aliens. Right? So the naturalization power is not the same thing as natural-born citizenship. That when Congress acts under Article 1, its limited enumerated power in the written Constitution, it is acting on aliens and aliens only. So the very first Naturalization Act is 1790, and this is an important act that a lot of people point to because of its language. The congressmen are debating how do we go about who do we want to naturalize, what should be the process, et cetera. And two congressmen mention specifically, we need to provide for children born abroad to Americans. In other words, we know they're aliens, we need to provide for them. And so in the very first Naturalization Act, which is 1790, they provide that children born abroad to American citizens are going to be citizens as well, but they use the phrase natural born. And so everybody says, aha, that must mean something, although commentators don't really they don't agree on what that something is, but it must mean something. But I'm going to point to what I think is much more important, which is that 5 years later, James Madison is appointed to redraft the statute. He deletes the statute language that says natural born. He's said in Congress that Congress doesn't have the power to act on these people. He deletes that phrase, and it's gone, and it never comes back. In addition, a treatise writer in 1803 said that here are the naturalization statutes. He's a professor, by the way, professor at William and Mary, one of the very first law professors in the United States. And he says, here's the statute in 1790, here's the statute in 1795. It takes away all disabilities from aliens except those people naturalized, which includes the children born abroad to American citizens. Those children naturalized by that statute can never be president of the United States. So the language that's used by very important writers of the time, at the language was drafted, says that they apply the common law. Last question, so what, right? What do we care? Should we be guided by those writers of the early day? As I said at the beginning, I'm not an originalist, and I will now reveal that I believe that our Constitution evolves over time. I think that our understanding of the Due Process Clause has changed over time. Our understanding of the Equal Protection Clause has changed over time. However, I am an originalist to this extent that I believe from the writings of the framers that they meant much of the Constitution to evolve over time. However, they felt there were certain parts of the Constitution that were crystal clear, would not be open to debate, and would remain constant. And one example that I saw a framer give was Article 3, the article that controls the judiciary. The framers figured that, either you're diverse citizens or you're not. Either there's an ambassador involved in litigation or it's not. There isn't really much to debate about it. Although as a federal courts professor, I will say that we do find some things to debate about it. But anyway, I believe, I've concluded, although I'm not saying I'm right, or this is the only view, but I have concluded that the Natural Born Citizen Clause, when read as a whole, has 3 very specific, crystal clear limitations. You have to be 35 years old. There is no debate about that. You have to be 14 years a resident, no debate about that. And at the time, natural born citizen was an obvious, crystal clear term to the framers. And so it seems to me that in interpreting it, this would be one of those clauses that should maintain its original meaning. Anyway, take it for what it's worth. That's my 2 cents.
Thank you, Professor McManamon, and now Professor Epps.
Thank you. Let's see, I want to start this thing so I don't talk too long. And if I do, give me a high sign, right? There are a number of big lies. Of course, I'll marry you, checks in the mail. I'm from the government. I'm here to help you. The biggest one is I'm a law professor, and I'll be brief, but I'm going to try. I want to start with a fairly disturbing fact, and that is that as of this weekend, as of this past weekend, Donald Trump has now officially widened his birther attack on his enemies to include not just Senator Cruz, but now Senator Rubio, who was born on U.S. soil as a child of 2 lawful permanent residents. And he said on TV, he says, I'm not saying that, I haven't really looked at it. I know some people have looked at it. Somebody said he's not, I don't know. We need to start a dialogue on this, which is precisely the same way he began the attack on Senator Cruz, which at first he said, I don't know, lawyers need to look at it. By the time of the primary voting in Iowa, he was calling him the anchor baby. Okay, so there is a reason why, though I'm always thrilled to come to the University of Maryland, I sort of regret that we are engaged with this conversation at this time. There's something very odd going on in our country. Donald Trump seems to have an almost satanic power to control the dialogue about any given subject, going all the way from the pool halls and the streets up to the academy. And so now we are sort of seriously debating whether Senator Cruz can be president. We probably will be debating 6 months hence whether Senator Rubio can be president. I feel like a character in a road company of Ionescu's Rhinoceros, the central characters. Every person in his village slowly turns into an angry rhinoceros who cannot be reasoned with or use human language. And that seems to be happening to our country. Now, I exempt all the people in this room from that, but there is something very disturbing happening in the country, and I resent the idea that national dialogue is going to follow Mr. Trump's lead. But I have to add quickly, I even more deeply resent, just on a lifetime basis, any turn of events that constrains me to say anything even remotely passively positive about Senator Cruz's campaign for president. Until I met Senator Cruz, I always thought that the phrase, "my blood ran cold," was figurative. Now I know that it is not. I think the question is, how did we get here? And I think to some extent, the injection of this issue into the dialogue, the non-academic dialogue, comes as a kind of a fairly waspish and mean-spirited and typically pachydermatous academic prank by people, most particularly Professor Lawrence Tribe of Harvard, Professor Sunstein also. Professor Tribe took a kind of malicious pleasure in an op-ed in the Boston Globe where he said, according to Cruz's lights, he wouldn't be eligible to be president. The kind of judge Cruz says he admires and would appoint to the Supreme Court as an originalist, one who claims to be bound by the narrowly historical meaning of the Constitution's terms at the time of their adoption. And to this kind of judge, Cruz wouldn't be eligible because the legal principles that prevailed in the 1780s and 90s required that someone actually be born on U.S. soil to be a natural citizen. And then he adds something very revealing. He says, well, and when Cruz was my constitutional law student at Harvard, he aced the course by making a big deal of how much he opposed my views, arguing for the original meaning against the idea of an elastic living constitution. So I think there's a kind of somewhat unworthy puncturing of the Cruz balloon going on. And I think that his statement that the legal principles in the 1780s and 1790s is too glib. I'll try to explain that to some extent. And I think he also knows perfectly well that a serious originalist judge or scholar doesn't uniformly claim to be bound by the narrowly historical meaning of the Constitution's terms. The movement is a good deal more sophisticated. I used to be an originalist, but I was expelled from the movement for deviationism. Nonetheless, I think that it is worth taking seriously the movement itself rather than caricaturing it. Finally, I think that the idea that there's a lot of interest in this discussion that is about the common law and statutory background of the framing and its intellectual background on this area, it's arguably harmful because the meaning of natural-born citizen, as far as I can tell, is entrusted to Congress. I don't believe we are dealing with a Da Vinci Code constitution in which that provision directs us to go find old parchments and work it out. I think that Congress is given the power to decide on matters of citizenship. Congress has decided on matters of citizenship. Under Congress's legislation, Senator Cruz is a natural-born citizen, and I think really that's the end of the story. Now, let me say that one of my concerns about originalist scholarship concerns the burden of proof, because I think anyone who has done serious reading or work in history understands that when you are presented with a historical question, what happened on this date? What did people mean by this term? What was in the mind or the intention of this historical actor? We don't really have a kind of tort system in which we just sort of say we have to make a decision and we look at all the evidence, and if there's a feathers more evidence on this side than on the other, then that's what we decide. The basic principle of history, it seems to me, is that we don't know. The past is unknown. And that in order to establish with anything like certainty the meaning of historical events or terms, the quantum of evidence has to be a good deal more than preponderance. It has to be fairly clear and convincing. I don't think in this circumstance it is. Blackstone is often used as, and because of the short amount of time I have, I'm just going to focus on that. He's often used as a summary of the common law that would have been greatly influential to the framing generation. Blackstone's discussion of the right to bear arms, for example, has influenced our jurisprudence on that area. In Blackstone, which is often quoted, he says, an alien is one who is born out of the king's dominions or allegiance. The common law indeed stood absolutely so, with only very few exceptions, so that an act of parliament became necessary after the Restoration for naturalization of His Majesty's English subjects, born in foreign countries. But very often they neglect to quote what comes shortly after, in which Mr. Blackstone says, by several more modern statutes, these restrictions are taken off, so that all children born out of the king's allegiance, whose fathers were natural-born subjects, are now natural-born citizens themselves, to all intents and purposes, without any exception. So he is speaking of a statute passed by Parliament called the British Nationality Act 1730, obviously enacted and made part of the law well before the framing of the Constitution. And I think that he is explaining a principle, one that is quite important both to the common law and also to constitutionalism as it is practiced in the United States. And that principle was that Parliament, as the legislative power of the realm, had within its control the meaning of natural-born citizenship, that there was no fixed meaning of this term, stable over time and across boundaries. And I believe that the term was put in the Constitution with the idea that Congress would apply and make use of it, which, of course, Congress has done in our modern statutes. Now, just because it's a fun game to play, and I have so much enjoyed reading Professor McManamon's article and so forth, I will offer my own view of why this clause is in the Constitution, with the understanding that, you know, this is my kite, right? And I don't claim that I have discerned the determinate meaning of the term. I believe that it was a hasty response to a possibility that was widely discussed at the time and that was, in fact, based on real events, that some faction within the new republic would turn to a foreign prince. Prince Henry of Bavaria, I think, was one who had actually been contacted by someone who was later a delegate to the Constitutional Convention and asked, would you like to be king of the United States? We are not going to be able to forge a country with a democratically elected executive. We will need a foreign prince. Others were going on. Baron von Steuben was in correspondence with various people of the blood royal, mostly from Germany and Austria. I think the statute that they had in mind was what a statute called the Sophia Naturalization Act of 1705, a parliamentary law declaring Sophia of the Palatine, Electress of Hanover, and, quote, the issue of her body to be naturalized British subjects. The issue of her body was George I, George II, and George III, the Hanoverian dynasty. Naturalization, among other things, was the way that a country shopped for a king. If you put natural-born citizen into the Constitution, the one thing we know is that Congress will not be able to reach out and naturalize Prince Henry of Bavaria and make him king of the United States. I offer that as a theory, and I think it's worth, playing with, or at least it's fun to play with. But while all of this is fun, I have a real objection to the dialogue as it's being carried out in this country, and that is what is coming and has been coming for the last few years and has reached a toxic point in the current presidential campaign is an ongoing and very dangerous attempt to forge more or less out of thin air, and let me just make clear, I'm talking about political actors, I'm talking about political movements, I'm not talking about scholars, because, the whole deal of being a scholar is that we throw this stuff out there and we play with it and we try to figure out what it means, and it's great fun and I think educationally very valuable, but I am talking about a serious political movement to forge more or less out of thin air a meaning of membership in the American polity that will be, for the first time in at least 150 years, what I will call tribal. Now, I mean no disrespect to actual tribes, right, who have every right to define their relationship to the national government in terms of the blood quantum of their members. But the United States has not had, at least since 1868, and probably since 1863, a tribal character to membership in the population. The same people who are putting forward politically the idea that Ted Cruz is an anchor baby. Marco Rubio is the child of lawful permanent residence. I had someone write to me and say, the citizenship clause of the 14th Amendment is just fine, but it only applies in the territory of the United States at the time it was passed. So someone born in Oregon is not a citizen of the United States. This kind of emergence from the sleep of reason of these racialized monsters of what it means to be an American is really very dangerous. And we can see that the dialogue about natural-born citizenship has spread from Senator McCain to President Obama to Governor Romney, now to Senator Cruz, and now to Senator Rubio. It is corrosive as a political dialogue. America is not tribal. America is not racial. America is not a land forged by blood. America is a cosmopolitan nation. Our citizenship laws recognize this. And our political system, to the extent that it turns away from it, is doing a grave disservice to the future of our country. So with that, I will leave it, and we'll hear from Professor Brigid.
Thank you, Professor Epps, and now Professor Graber.
In 1608, Nicholas and Richard Smith appear before Lord Chief Justice Edward Coke, and they say they are entitled to possession of Robert Calvin's land because Robert Calvin was born in Scotland and owes allegiance to King James VI of Scotland and not King James I of England. Robert Calvin, who was 1 year old but very precocious, points out that James VI of Scotland and James I of England are the same person. Whereupon we reply, well, they may be the same physical person, but they're two different legal people. And from Calvin's case, the Anglo-American understanding of citizenship evolves. Now, what I'm going to present to you is somewhat differently. I am what's called an historical originalist, and that is I really do try to recover what people were thinking at the time they were thinking. But the difference between an historical originalist and a legal originalist is whereas one standard argument against originalism is it's unknown. In fact, that puts us out of business. We don't think it is unknown. We think it's unusable. We think what you discover when you look at understandings of citizenship or equality or liberty 300 years ago is that the meanings are so infused with assumptions we don't make today or are in such transition that they simply can't be applied to the problems. So we start with Lord Coke's decision in Calvin's case, which has pretty much been gone over. The crucial feature is you are a subject, very important subject, not citizen. Word citizen is not used in Calvin's case, of whoever's protection you were born under. Now, it's fairly obvious if you're born in the realm that you are, in fact, a subject of the king. If you are in the king's army abroad, and for some reason there must have been women in the king's army because they were giving birth, you are, in fact, under the king's protection. If you're the ambassador, you're under the king's protection. And then Coke says, and there are other people. Who are they? We don't know. For some reason, Coke decided he wasn't going to talk about exchange students, and he wasn't going to talk about women exchange students. Why? Your guess is as good as mine, and probably the same as mine. Namely, there weren't any. But we have this vague category of other people under the protection of the king. But the important thing Coke says is, I'm going to make life simple for law students. That is, first, you are either a subject or an alien. There's nothing else. Second, if you are a subject, you are either a natural born subject or a naturalized subject. There's nothing else. And what I'm going to argue is that what Americans do in the late 19th century or 18th century is totally destroy these categories. And they do so, and then they write a constitutional clause that if you were to produce that language today in a legislative drafting case, we would give you, now it's probably 50 cents or $1, tell you to call your parents and say you're not going to be a lawyer. It is one of the worst drafted clauses in the Constitution of anyone. So here's the problem Americans faced. We weren't subjects of a monarchy. We were citizens of a republic. Now, one rule might be that it's very simple. The day we declared independence, you stopped being a subject, you became a citizen. Same rules applied for citizens. Turned out most states don't apply those rules. You get a choice. You can elect. Do you want to be a citizen of the United States or not? And so most people elect citizenship, but now we have this vague third category. We have these people who are clearly aliens. They were born, say, in Germany. They came over. They haven't yet been naturalized. We have people who are clearly citizens. These are people who took the citizenship oath. Then we have people that are born in Virginia. They're not subjects of England anymore. They're not citizens of the United States because they haven't taken the oath. What are they? We don't know. Then we get another class of people. See, one notion of Republican citizenship was there was something wrong and futile about birthright citizenship. The idea that there was no consent, you were just born whether people liked you or not. The idea is, as good Republicans, governed by consent means we consent who belongs to our club. And guess what? A lot of Americans said non-white people do not belong to our club. And so, again, you had a problem with free persons of color. Now, in some states, they said they're citizens. Other states, and increasingly American law goes, well, they're not citizens, they're not aliens, they're something else. So Americans begun creating new categories, and one of the things the Constitution might do is, since we're creating new categories, we better define them. And not only doesn't the Constitution do that, but it uses language that just defies public meaning originalism. So, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Well, let's start with number one. If you had given this clause to a person who knows nothing, just find out the meaning, the way the commas are structured, it appears the following must be true. To be a president, you must either have been a natural-born citizen at the time of the adoption of the Constitution, or, in fact, a citizen of the United States at the time of the adoption of the Constitution. Okay, here's the good news. Ted Cruz is not eligible. Neither is Donald Trump. Neither is anybody else. Because there is nobody who is alive who was a citizen or a natural-born citizen at the time of the adoption of the Constitution. So the first thing we have to do is we have to rearrange the commas. And by the way, it's very clear, original public meaning does not allow us to rearrange the commas. That's what they wrote. That's what they meant. Second problem. you have to be, we've rearranged the column, a citizen of the United States at the time of the adoption of the Constitution. When was the Constitution adopted? First thing you discover is that there actually is no clause that points on this date it is adopted. The closest we get is Article 6, which said this Constitution shall take force, or meaning when ratified by 9 states. The remaining states, New Hampshire was 9, it's Virginia, New York, North Carolina, Rhode Island. So if we understand the Constitution was adopted when ratified by the 9th state, there is a sense in which George Washington was not a citizen of the United States at the time the Constitution was adopted, since the Constitution says the 9. So you say, well, actually, it turns out there was something called the citizen of the United States before. They were referring to that. I'm going to hold off on that problem for a second. But if that's what you mean, now you've got the Rhode Island, North Carolina problem. When George Washington took the oath of office, Rhode Island and North Carolina had not ratified the Constitution. So could it possibly be the case that a person from a state that did not ratify the Constitution would be eligible to be president? In other words, if by the technique you get George Washington in, you also get in people who are not members of the United States as of 1789, since all that matters is whether you were a citizen of the United States under the Articles. And you wind up with that problem. Now we also have to decide, was there something called American citizenship? Well, if we believe the Tea Party, the Constitution was a compact between the states. States were sovereign. The Constitution was sort of the federal government like a UN. Well, none of us refer to ourselves as citizens of NATO, of citizens of the OAS, of citizens of the United States. So in fact, the citizenship clause then for Ted Cruz to make it work has to say Ted Cruz's theory of the United States is wrong, because we need to find out how people could be citizens of the United States under the Articles, and it's not quite clear that category exists. Well, now we get to the ultimate thing. What's a citizen of the United States? And guess what the Constitution doesn't say? There is no citizenship clause. And this causes all sorts of problems. So to take a very simple version of this, there's a man named William Smith, who was born in South Carolina, but like lots of rich people, decides to go to England for education. And it turns out he's in England in July of 1776, and for lots of reasons can't get back for a little while. And he finally gets back, and South Carolina sends him to the Senate, and there was objections raised. Why? He wasn't in the United States July 4th. Therefore, he could not be a citizen of the United States unless he was naturalized. What's the constitutional answer to that? Answer, we have no provision. So, for every complex issue of citizenship, and all of them arise in the state, the Constitution doesn't tell us. It says you have to be a citizen of the United States, but we have no idea what that means. Now, it would appear that the 14th Amendment changes that. 14th Amendment at least says all persons born or naturalized in the United States are citizens of the United States. We now appear to have gotten rid of the, you didn't take the oath of citizenship, you're a free person of color. But it turned out that even then, we get a mystery. Mississippi sends Hiram Revels to the Senate. And Democrats raise an objection. Why? I believe, and Tanya, you can correct me if I'm wrong, that Revels was the first African-American on the Senate. There were a couple of others later. Revels was the first. They say, well, but Revels was a slave. He was only emancipated either in 63 or 65. The Constitution says you have to be a citizen for 7 years. Well, when he was a slave, he wasn't a citizen. And we look at the 14th Amendment, and who knows what that means. Now, what I've tried to suggest is if we take the Constitution literally, it just confuses you. I sometimes say in con law, please don't read the Constitution, it just confuses you. We'll just read the cases. But the public meaning is confusing, but the answer is very clear about what Americans have actually done. When people have pointed to the paradoxical language, yep, South Carolina cranks who didn't like William Smith made a fuss, William Smith gets seated. Democrats made a fuss, Hiram Revels gets seated. So the answer tends to be when the plain meaning of the Constitution runs out or defies common sense, we decide, no, Zachary Taylor will not be the last person eligible to be president of the United States, that we will move the commas and do what we have to do to make our practice, if not our text, consistent with common sense. Thank you very much.
Well, I want to thank all three of our speakers for terrific insights on this question and invite questions from the audience.
Are there any other places where the term natural-born citizen is used in the law today, or are there any distinctions between what a natural-born citizen or a naturalized citizen can do in the United States other than be president?
As far as I know, the only place it's used is Article 2, Section 1, and the only difference between them is one can be president and one cannot. Otherwise, everything else is fine.
There is one, I think, small exception to that, which has become quite important during the Nazi war criminal prosecutions, and that is a naturalized U.S. citizen can be denaturalized if it is shown that he or she actively deceived in their application for citizenship. So Mr. Demjanjuk, who said, you know, I'm just an innocent Ukrainian, turned out to have been a guard at Treblinka, and his citizenship was revoked, and he was extradited to Israel. I don't know of any other, right? And I don't know of the term natural-born citizen being used. I think that the distinction that is important throughout the law is between naturalized citizens and citizens by birth. And I think that I personally think that's what the background is of this entire matter.
My question is probably a little out to left field. We know that Cruz's father was a naturalized Canadian citizen. And the question, and there's been some stuff in the press about whether his mother was also listed on the Canadian rolls and therefore eligible to vote and therefore a Canadian citizen at the time of his birth. And so I want to know whether anybody knows about the impact of naturalization on the legal status of a non-Canadian wife, whether it is possible that Cruz's mother may have had both Canadian and maybe even American citizenship, and whether that would have had an impact on the whole question of whether, of his eligibility.
Well, I can tell you with some confidence the early 19th century version of this, and it's absolutely fascinating in some ways if you ignore the fact that it's also sexist, racist, et cetera. And there are a series of cases about property confiscation of loyalists in circumstances where it's actually the woman who has the property. And the 19th century rule, Justice Story and a few others, was no, when a woman leaves the United States to be with her spouse, her non-American spouse, she surrenders her citizenship. But because it is not her will, but her will, the will of her husband, which she is bound to follow under the common law, unlike a loyalist, she does not forfeit property and her heirs can inherit. So the answer would be if Cruz had done this before the Civil War, she would have been deemed denaturalized. But again, as most people know, my knowledge really doesn't extend much beyond 1835.
It's been a while since I taught immigration law, but my understanding is that in order to lose your citizenship, dual citizenship is actually permitted. In order to lose your citizenship, you must affirmatively renounce. Lee Harvey Oswald did that. For example, when he went to the Soviet Union, he went to the consulate and said, I don't want to be a U.S. citizen anymore. And I have a number of friends in Europe, American-born friends, who have done this because it exempts them from dual taxation. It's actually quite an expensive proposition. It used to cost $300. Now I think it costs $1,400. To the best of my knowledge, there's no record of Mrs. Cruz renouncing, and therefore, whether or not she was considered a Canadian citizen, just as whether or not certain people are considered Israeli citizens or also British citizens, I don't think it has any bearing on the status of her offspring, because that's governed by the statutory provisions, which don't, as far as I can tell from reading them, don't have an exception for children born to dual citizens.
I just want to make 2 points. One, I would take the position that his parentage is completely irrelevant. If he were born in America to two Canadians, he would be an American citizen, a natural-born American citizen, and whether Mrs. Cruz was a Canadian or an American, it doesn't matter. I also just want to tack on, the sexist provision actually extended into the 20th century. I found a case, and I can't remember the name now, in which a woman in California married an Englishman. And one day she decided, I think she was going to run for mayor of San Francisco, something like that. And she went down to register, and they said, well, you're not an American. She said, well, of course I'm an American. I was born and raised in California. Nope, you lost that when you married an Englishman. So that went into the 20th century. I just thought I'd throw that out there.
Born in Canada.
Pardon?
Cruz was born in Canada.
I know that.
Okay, so so you're still saying that he would.
He's not, as far as I'm concerned, he's not eligible for the presidency because he was born in Canada. His parents' citizenship is irrelevant.
Okay. Long ago, I wrote an article on Luther Martin, and I did original research, which I shall never do again. But I found a reference to John Quincy Adams in 1812 when he was our ambassador to St. Petersburg. And he sent his wife home in the middle of the winter because she was pregnant, and he wanted her to have their child in the U.S., so he would be a natural-born citizen. That's Charles Francis Adams, who never made it, of course, but he ran. Have you ever run across that? I mean, it was in the Maryland Historical Society.
Yeah, I actually ran across something very similar. It wasn't John Quincy Adams, and I've looked and looked and looked and can't find it. When I was a kid, we used to go down to Ogilvy Park, West Virginia, in Wheeling, West Virginia, for vacations. And there was this wonderful old mansion you could tour. It was a big coal mining family. And I remember two things about the tour. One was that the entrance to the mine was in the kitchen, and the miners would come into the kitchen, and the lady of the house would hand them a cup of coffee as they went down the mine. But the other thing I remember was that she and her husband were in Japan when she was pregnant, and she said, "We've got to get home as fast as possible because I want my son born in the United States."
And John Quincy Adams would have known the intent of the framers. It's very interesting.
I just like to add to that. I'm not sure, first of all, I'm not at all sure that John Quincy Adams would have known the intent of the framers. He was a teenager at the time and not present at Philadelphia. But beyond that, I think the question really is, and this is the only point the only reason I'm here, is that the question is not, it certainly isn't what John Quincy Adams thought the law was. It is not what the law was in 1812. It is what is the law when Senator Cruz was born. And I don't think that law is terribly unclear. I just think he's a citizen, and you are only a citizen one of two ways. One is by naturalization. Senator Cruz was never naturalized. There's no naturalizing papers. Or by birth. There is no third way to become a citizen. You know, as far as I'm concerned, end of story. John Quincy Adams, I yield to no man in my respect for the sage of Quincy, a wonderful, wonderful man, but I'm not sure that it has a lot of bearing on the question we are here today to consider.
Would you like to respond to that?
Well, a couple of things. First of all, I gave my anecdote, and I took the anecdote as evidence of what Americans in general believed the meaning to be, not necessarily the framers, but that term was in common use and understood up until relatively recent times. And the second thing is that according to the early writings, even though Senator Cruz may not have prepared papers of naturalization, the statute, Congress having the power to naturalize, the statute that declared him a citizen naturalized him, and that's recognized in a case of Rogers versus Belli. And finally, the term is citizen, not natural born. And so, yes, there is absolutely I have no question that Senator Cruz is an American citizen, but that's not the same thing as we're talking about.
Hi. So in 1968, I guess, in response to George Romney running for president, the Maryland Law Review published an article by the then General Counsel of the INS, who makes a lot of the same points made here, not really any of the historical ones. But he concludes essentially that there's doubt on both ends. His argument in the conclusion, though, is interesting because I don't think it really was addressed here. So just to quote the last two sentences, all of these, and he's talking about the parents of people who are abroad, have a right to retain their status as American citizens while they live abroad and their privileges. One can perceive no sound reason for shutting off aspiration to the presidency for the children born to them while they are temporarily sojourning in foreign countries. So what really interested me about that was it was framed in terms of the privileges of the parents and the rights of the parents who are themselves American citizens abroad. And I was wondering if that has any legal effect or if you've come across anything arguing that.
One feature of this, which I should have mentioned and forgot, which is under English law of subject, you could not by yourself change allegiance. That is to say, if you went to France, you couldn't say, I'm a French subject. The French king could not say you were a French subject. If you were born under the protection of King Henry, you were English unless King Henry said, you're out of my protection. And by the way, it is very crucial to the American Revolution that a few months before the Declaration of Independence, King George issued a document saying the American colonists are out of our protection. And they said, good. But now here's another paradox. A great many Americans, and particularly Jeffersonians, regarded the doctrine of out of the king's protection as monarchical. They claimed a Republican citizen had the right to say what state they belonged to. Federalists disagreed. And so it may matter very much to how we resolve this problem and how we think the framers resolved this problem. Was it the case that when people traveled to Canada, they were free to say, I'm here to be a Canadian? Or they could never say, I'm here to be a Canadian unless we said so, because that may affect the status of their children.
Other questions? So I'll throw out a question to Professors McManamon and Professor Epps. So I'm very interested in the different ways each of you have framed the historical inquiry into the meaning of the natural-born citizen clause. And I want to just sort of test the difference in your framings to just give you a chance to respond to each other. So as I read Professor McManamon's reading, the fact that Congress, through its naturalization authority, can enact a law that retroactively confers citizenship right to the moment of birth for children of a U.S. mother who are born abroad doesn't have any bearing on the status of that child as a natural-born citizen, because natural-born citizen has a sui generis, a very distinct meaning that is separate from naturalization, which goes back to my earlier comment about the difference between the meaning of the word natural in the context of natural-born citizen versus the word naturalize, Congress's power to naturalize. So that's one piece. The flip side is Professor Epps' observation about the British Nationality Act of 1730, which is antecedent, of course, to the writing of our Constitution and even to the American Revolution, which lets children of natural-born citizens under British law become natural-born citizens. And so, in a sense, this sets up a question for each of you. It tests the limits of each of your arguments, and I just would love to give each of you an opportunity to respond to each other on that framing.
I'm not 100% sure of where you mean me to go, but...
Well, so for you, the question is whether the 1730 Parliamentary Act, which conferred natural-born citizenship status on the children of natural-born citizens in England, has a bearing on the contemporaneous public meaning of the natural-born citizen clause that we're debating today.
The writings of early Americans that I have seen indicate that the statute was not adopted here, that meaning was seen as an anomaly of the British Parliament at that time. And a couple of different reasons for my conclusion is that one is that the Parliament at that time was supreme to the Constitution in Britain. For example, in an anti-Catholic move, it just totally changed the line of succession after the Stuarts in order to get rid of 52 heirs to the throne at one moment because they were all Catholics. So too, it could just throw up the established meaning of who was a subject and who wasn't a subject. Our regime is exactly the opposite. That is, Congress is limited to its enumerated powers in our Constitution, and its power is to naturalize. And the "lize" means it can only act on aliens, turning them into citizens. So, I mean, that would be my position. And the other thing is that there's a writer I didn't mention before from the 1850s. He's writing about the issue of slavery, and if you're born in the they were taking the position, if you're born in the United States, you are a natural-born citizen. That means anyone, including African Americans, this is before the Dred Scott decision, would be a naturalized citizen. So he's writing in that context, and he says the common law, which is what we adopted. We have no reception statute adopting a statute. The common law never had any concept of parents giving the citizenship. So that would be why I would conclude what I conclude.
Professor Epps?
Yeah, I think I have kind of two responses to that. And the first one is simply this. I think that to say that, you know, Britain had no written constitution, so Parliament could do what it wanted. In America, the Congress is restricted only to what's written in the Constitution. Really kind of affirms the consequent. That's, I think, a misconception about what the Constitution does. The Constitution is not primarily written to limit Congress. If you read the Constitution, its primary aim was to create and empower a Congress that would have legislative authority to govern the affairs of a new country. The framers and ratifiers of the Constitution were terrified that the country would fall apart and be gobbled up by European powers because its government didn't have enough power. And so some of the terms, you know, that even Professor McManamon uses, such as habeas corpus and due process of law, these are terms that Congress has fairly broad authority to define, and I think was always understood. Habeas corpus only takes place within a framework of jurisdictional statutes. I mean, anybody who's ever had to deal with an AEDPA offense can tell you that. The jury trial, which is another one that she mentioned, is a really interesting test case because the right of trial of a civil jury is explicitly by text related and limited to the existence of the common law. Okay, so that's what the framers of the Bill of Rights knew to do when they wanted to say only the common law will prevail. And many of these terms are not so limited because the idea, think of all the things Congress gets to decide. They get to decide who is president, who becomes president after the vice president. They get to decide whether there are federal courts. Congress has enormous amounts of power, and I think I think it's a misconception to think that the framers somehow wanted Congress for the rest of time to go and look at the parchments of the common law and regard itself as being unable to act in matters of citizenship in any other way. That I just think is a hermeneutic that doesn't actually apply to the Constitution. And it is not anything that attacks the idea of a written Constitution because the Constitution does contain explicit limits on Congress. Bill of Attainder is one example, and Congress can't vary those. But where it is not explicitly forbidden and where, in fact, textually it's pretty clear it's being given authority, I think Congress can exercise it to the full extent. And Congress has done that. We are once again, let's just remember, we are talking about the law today.
Professor Graber, did you want to chime in on this?
Other than I think what the difference is what's the definition of natural born? In particular, on one sense we have, well, it's for purposes of Article 2, natural born is exactly who the framers thought would be natural born in 1789. On the other hand, it might be that if in other areas of the law, Congress is free to tinker and say the line between natural born and naturalized is here or here, whether when Congress tinkers with it in other areas of law, it also affects the meaning in Article 2. And the real problem is, since we have no constitutional definition of citizenship, it's just a mess. And in short, again, goes back to my thesis that if you ever produce something like Article 2, in a legislative drafting class, we will expel you.
Professor Quint?
So, without a lot of confidence, I do wish to raise two kinds of questions which really haven't been, I don't think, touched on here. The first is, what does natural mean? I mean, this is a peculiar word to do whatever it's supposed to do. It's a peculiar word. If they really wanted to say you have to be born a citizen, they could have said that much easier. So that's an oddity, and it seems to me it would be interesting to sort of go back. I mean, these authors were classicists. They had probably read Democritus and so on, who talks about the nature of things. And so what they meant by natural is something, there probably has been some work done on this, but I don't know. It could be, you say, what is a natural-born citizen? Well, you could say a natural-born citizen is a citizen at birth. Now, you could be more mystic and say give some tribal explanation, so by the deep essential nature an American, but we don't have to do that. And say, well, all right, a natural-born citizen is a citizen at birth. Now, maybe at an early point there was only one way you could be a citizen at birth, and that was by being born in the way people thought of it, even though there was no phrase, by being born within the geographical confines of the United States. But later on, where Congress has, we will assume constitutionally, enacted statutes that make people citizens at birth, such as if they are the children, thank you, such as if they are the children of American parents abroad, then maybe it's not unreasonable to say these, even in the framers' view, these are natural born because they were citizens at birth, even though they were citizens at birth in a different way from the traditional way. So that's the first question. What does this word nature mean? And an additional wrinkle is this idea of naturalization is very peculiar. You're given a nature. You didn't have that nature, now you're given the nature. So that's the first kind of question. The second kind of question, I'm a little bit more surprised hasn't been discussed, because it's the nature of American law schools to decide these, to argue these questions. What's the purpose of this? You know, isn't that what we deal with from first-year torts on, first-year contracts? What's the purpose of this? I mean, we don't really need Justice Holmes to tell us this, although he did. So what's the purpose of the provision? Well, I mean, why do we have it in there? Well, it seems to me the only thing that's ever occurred to me on this is that we want the president to be super loyal. You know, all citizens have to be loyal, and in fact, you have to be a citizen to commit treason. That's the enforcement of this loyalty, or at least one of them. But we want the president to be super loyal. So we say the president has to always have had this loyalty. And if that's the case, then if by statute a person born outside of the United States to parents who are citizens has always from birth been a natural citizen, he's also, or she also had this loyalty from birth. So that's a way of, that's a different, another way. I mean, these are two questions that seem to fit together in a way and point to the conclusion that the despicable Cruz is qualified to be president, at least in this one respect. I guess you could argue that, well, if you're born outside of the United States, then you're likely to have a dual citizenship. I mean, if you're born to American parents and therefore American citizen, maybe you'll have a dual citizenship that might dilute your loyalty. But I suppose that people could be born within the United States who have dual citizenships according to the law of certain countries.
So we are actually up on the 1:30 hour.
Okay, well, so I just finished
Yeah.
that by saying thank you very much.
Okay, so I do want to give the panelists just a brief moment to respond. There is food outside in the atrium, but would somebody like to take a moment to respond briefly to Professor Quint?
I can answer a brief nugget portion of that question, and that is that natural born was a colloquialism of 17th and 18th century England and also in the United States. By the early 1800s, Chancellor Kent, for example, and the legislators who were involved in drafting the 14th Amendment are referring to it as native born. So the meaning that was seen at the time was native born.
I'll just say a couple of things very quickly. The first is just in my own behalf. I have to say I have discussed the provision in terms of its purpose. I did. And I regard my proposed purpose of meaning as being fairly powerfully explanatory, that the reason that the clause is in there is to prevent foreign princes from acquiring naturalized citizenship as part of an act awarding them the throne. That's a proposition that can be tested historically, but I think that is my initial take on the purpose. The second thing is that I'd like to point out one of the great moments in literature that has to do with executive succession, which the framers were aware of, and that is Act 5 of Macbeth, in which Macbeth is confronted by Macduff, and he says, "Aha, Macduff, none that is woman-born shall slay Macbeth." And Macduff says, "Wah-ha-ha-ha on you. Macduff was from his mother's womb untimely ripped." And then he slaughters Macbeth. So there's natural born had some sort of biological meaning. And taking that forward, I wrote in 2012, long before this issue became really heated, when Trump was making noise about running for president, that I would grant that he was a citizen. I would grant that he was born in the United States. But as I look at his hair, I do not grant that he was natural born.
On that note, I'd like to thank our, oh, no, not quite yet, go
I
ahead.
got a little something. No, natural born in the 17th century refers to law of nature. That Koch refers to, this is the theory of subjects by the law of nature. And the major problem Americans have is they take a medieval concept, namely the land determines where you are, and are trying to jimmy-rig it to a republic, and it creates all the messes we're talking about.
On that note, thank our panelists, and please join us in the atrium for some refreshments.